Hello to everyone, and welcome to the second day of our summer school. We're just waiting for a few more participants to be admitted into the session. I'm sorry, we're running 1 or 2 minutes behind. We had a minor technical issue which we, with fantastic support from Jamie, managed to resolve without too much panic. So we are, I think, just about ready. So thank you very much for coming this afternoon. And this is the session on transitional justice. Our first speaker and in a way, the host of the session is Professor Colleen Murphy from the University of Illinois at Urbana-Champaign. And Colleen will be speaking for about an hour and taking questions in that time. And then we'll have a short break, and then the papers from the other 2 participants who I'll introduce later on. Now, if you want to ask a question, and we will encourage you to do so, we suggest you put your question in the Q&A, which is open even now, and we will go through those questions, and I will ask Colleen the questions on your behalf. So let us hope this all works very smoothly. We are recording this session. Of course, none of your faces or voices will be on the recording, but if you ask a question, I will probably read out your name, so that will be in the recording. So delighted to be able to welcome Professor Colleen Murphy from University of Illinois, who's going to speak to us now on transitional justice. So over to you, Colleen.
Great. Thanks so much, Joe and Professor Wolf. I thought I'd begin by linking what I'm going to be talking about to the discussion of social equality yesterday, and then situating it in terms of the sessions to come. I'll then talk about the particular political contexts that are of interest to me in talking about transitional justice, and what I call the 4 circumstances of transitional justice to pick out those contexts, what the aim of justice is in those contexts, and then 3 moral challenges that come up and how we might think about responding to those challenges that arise. So first, looking back, reaching forward is a refrain that's used to articulate what transitional justice is all about. So looking back to the discussion of social equality yesterday, there are 2 key points of intersection. One is that the view of transitional justice that I defend in my work takes as its point of departure the idea that justice is about relational equality. And the concern of transitional justice, one way of thinking about it, is how to both identify and also mitigate important sources of inequality that exists in communities. The second point of intersection is that to work in transitional justice is to work squarely in non-ideal theory. So the questions of transitional justice come up and arise against a background of deeply non-ideal sets of conditions. And so to fully understand sort of what the moral issues are and what would count as an adequate moral response, you really do need to work from the ground up. Looking forward, many of the conditions or circumstances that generate the need for transitional justice include recent histories of fascism, experiences with racism and broader racial injustice. And one of the consequences of pre-transitional periods is often widespread emigration, generating the creation of large diaspora populations. And so the topic of immigration and the place of diaspora populations in transitional justice processes is increasingly the focus of attention. Okay, so what are these contexts more specifically that I'm interested in and the questions that come up? Paradigmatically, there have been dozens of societies in recent decades that have attempted to transition away from extended periods of conflict or repression. So you can look at Argentina, one of many countries in South America following periods of military juntas, South Africa, which had an enormous impact on the scholarship and practice in 1994, transitioning away from apartheid to multiracial democracy, Rwanda dealt with post-genocide, the aftermath of the genocide against the Tutsi in 1994. Northern Ireland in 1998 had the Belfast Good Friday Agreement to end the Troubles and usher in a period of peace, an agreement that's now in tension with some of the core aspirations for Brexit. Egypt following the end of the Mubarak era, Iraq following the end of the Saddam Hussein era, Sri Lanka after the 26-year-long armed conflict there, and Colombia today as it aims to navigate an end to 52 years of conflict between the Colombian government and the FARC. One feature of these periods of repression and conflict is characteristically human rights abuses that are committed often on a very large scale. So to give one example, if you look at Colombia, which has a population of 48 million, according to the state's victims unit, more than 8 million have registered as victims since 1985. That includes 7 million forcibly displaced, hundreds of thousands killed, tens of thousands forcibly disappeared or taken as hostages or raped or subjected to other forms of sexual violence or tortured. So transitional societies have adopted a range of ways to deal with these wrongs, these abuses, as part of the process of a transition away from conflict or other forms of repression. So you see criminal trials at the domestic level, internationally, either with ad hoc tribunals like the International Criminal Tribunal for the former Yugoslavia. There's now the Permanent International Criminal Court, or hybrid tribunals, which aim to mete out justice as one of the pillars of transitional justice, framed as accountability for perpetrators. You also have truth commissions, which are official bodies that are established to document patterns of specific human rights abuses committed over a delimited period of time, trying to meet another pillar of transitional justice, which is truth. You find amnesty, which is the removal of the prospect of criminal or civil liability for either individual perpetrators or classes of perpetrators of wrongs. Reparations, which speaks to the third pillar that's often talked about in the truth, justice, reparation, and non-recurrence, which can be either symbolic or material. Public apologies, memorials, lustration, where individuals are barred from serving in certain public capacities. So think of cancel culture, here's public official canceling, and institutional reform, trying to contribute to non-recurrence. That's a non-exhaustive list, but examples of the kinds of processes that are set up. So the question that I focus on in my work is, how should societies deal with wrongdoing? Many transitional justice is a burgeoning field of multidisciplinary scholarship and practice. There's a wide range of empirical studies that focus on how societies do deal with legacies of violence and wrongdoing, understanding what are the factors that influence which processes are adopted, and what the impact of those processes are in a given case. But my interest is not so much in the first instance with how societies do make their choices, but in thinking about how they should. What are the metrics of moral success for dealing with wrongdoing in these moments? Insofar as we're going to say a society in transition has dealt with legacies of wrongdoing and injustice justly, what are the criteria or standards to meet, the metrics of success from a moral point of view? And there is deep disagreement about the answer to that question. So the thinking about the morality of transitional justice, what are the metrics of moral success, is not merely a theoretical question. It's one that drives, that citizens in transitional communities hold deep views about, politicians hold deep views about. INGOs involved in transitional societies have deep commitments with respect to, and there's a lot of disagreement. Disagreement both over particular processes, whether or not a truth commission can count as a just response to wrongdoing, whether punishment is a necessary or optional form of justice for perpetrators, as well as deeper disagreement about the criteria to use when making those judgments. Is justice fundamentally about retribution, so that perpetrators of egregious wrongdoing must suffer to be held to account? Is it about compromise, where you have multiple values that come into deep conflict in these moments, peace versus justice, or reconciliation versus justice, and you've got to find a way of striking a balance. Is justice about moving beyond divisions? These are all different positions that are defended. And so my work is trying to think about what would be a principled basis for adopting one or none of the positions I've just articulated about processes or about what justice means. So to think about that question, my starting point is an insight from 18th century philosopher David Hume when he speaks about justice, where Hume wrote that a set of circumstances of justice generate a problem, a particular problem for communities, which principles of justice provide guidance for resolving. Now, in Hume's own view, the problem of justice concerned the stabilization of property claims. And he noted that there are a number of circumstances that generate this as a problem, limited scarcity of goods being one. So that in contexts of extreme abundance, principles of justice aren't needed to specify or stabilize property claims. And in contexts of extreme scarcity, principles of justice are futile. They're not going to be of much practical purchase in shaping behavior. So I think what Hume's core insight is for thinking about transitional justice is the thought that principles of justice are context dependent. They become salient against a background set of circumstances that generate or give rise to a particular pressing question of justice. And so to understand the standards of transitional justice, we have to more deeply understand the context, or what I call circumstances of transitions. So I'll turn to how I characterize those contexts next. I argue in my work that there are 4 fundamental circumstances of transitional justice that we can see as characterizing societies that differ in many, many important ways, and that are realized more concretely in different ways in different contexts. The first circumstance I talk about is what I call pervasive structural inequality. So the subject matter here is the basic terms structuring interaction among citizens and between citizens and officials, where these terms are importantly dominantly defined by institutions of different kinds: political, legal, cultural, and social, economic institutions that help specify who is permitted or required or prohibited from acting in certain ways with respect to whom, and importantly, what are the penalties, both formal and informal, for violating the rules and norms governing conduct. Basic terms for interaction can be unequal in 2 ways. First, there can exist differential restrictions according to how institutional rules and norms define the terms for interaction on what individuals can do and become that's of value. So this is a reference to the idea of capability articulated by Amartya Sen and Martha Nussbaum, but where you look at the freedom enjoyed to be respected, to be recognized as a member of one's community, to avoid poverty, to be able to participate in political or economic institutions. So restrictions inhibiting the freedom of certain groups of citizens from being able to do this, and differential restrictions on the ability of individuals to shape the terms of interaction themselves. Every society has structural inequality. There's no society in which all institutions are structurally equal. But what's distinctive about transitional societies is the pervasiveness of structural inequality. Inequality rises to the level where the state could be deemed illegitimate in the sense that there exists a right to rebel on the part of citizens. And the fault lines of inequality vary across societies and contexts. Race and racial identity can be one fault line of equality that's salient in contexts like the United States and was salient and is salient in contexts like South Africa. You can also have gender and gender interacting with race in complicated ways, as well as ethnic identities or religious identities, where individuals live regionally and whether or not individuals are members of indigenous communities or not. So some or all of these fault lines exist in ways that structure the freedom that's enjoyed in terms of what individuals can do and become, and possibilities for shaping norms for interaction. The second circumstance that I talk about is what I call normalized collective and political wrongdoing, where wrongdoing refers to violations of human rights that become normalized in an empirical sense. They become a basic fact of life around which individuals must orient their conduct. So in the context of ongoing protests against anti-Black violence and brutality in the United States, the hashtags like sleeping while Black or jogging while Black signal the ways in which Black men and women in the United States become targeted for violence as a result of engaging in very normal, mundane activities and have to orient their lives around that fact. The consequence of the normalization of wrongdoing, morally speaking, is multiple-fold. One thing is that it means that the category of victim and perpetrator can become overlapping and apply to the same person at once. It also means that if we're going to understand what it takes to respond to normalized wrongdoing, we need to move beyond the binary of victim and perpetrator to include an analysis of the role of bystanders or collaborators or individuals who are complicit in wrongdoing, all of these roles that contribute in important ways to making normalized wrongdoing possible. Wrongdoing is not only normalized, but collective, often done by groups and targeting groups of citizens, and it's importantly political. Political both in the sense that it's committed by state actors or individuals acting on the behalf of or with the permission of the state. Contexts vary in the percentage of wrongdoing that can be attributed to the state, where it's the vast majority or the majority or some other percentage. But not only is the wrongdoing implicating state actors, it's often done for the sake of furthering political objectives. It's not personal in a certain way. It's done for the sake of maintaining the status quo and defending it, or of contesting the status quo, or of acquiring land or contesting land. And the form that rights violation take vary across transitional contexts. Disappearing citizens, torture, rape, land dispossession are some of the forms that it can take. The first two circumstances of justice often interact in mutually reinforcing ways, where background inequality can be used to justify normalized wrongdoing, either by diminishing recognition of the entitlements of members of a marginalized community to be treated in certain ways as being rights bearers who are entitled to having human rights protected and respected. Wrongdoing might be justified as necessary, though regrettable, in order to maintain a system of structural inequality. And conversely, one of the functions of normalized wrongdoing can be to entrench and protect structural inequality that exists. The third circumstance is what I call serious existential uncertainty. So the first two circumstances of pervasive inequality and normalized wrongdoing are circumstances that can be found in many currently unjust or historically unjust communities globally. What distinguishes transitional contexts is the presence of the third circumstance, this serious existential uncertainty that I mentioned, where that signals moments in which the status quo becomes called into question in ways that make the possibility of robust change possible, where it suddenly becomes deeply unclear what the future of a political community is. And that could be because there's been a peace agreement signed. And so suddenly the possibility of an end to conflict is on the horizon. It could be because there's a toppling of a dictator and a regime change. And so there's a promise of elections, though it's unclear whether elections will be held or whether the results will be respected, whether a cessation of violence is temporary or indeed permanent. And underlying what I call existential uncertainty is just the fact that a lot of transitions attempted fail. An aspiration to democratize may have a very small probability of success or moving beyond various forms of repression or conflict. In the context of Colombia, where you have this historic peace agreement that was labeled the final agreement, you have ongoing killing of human rights defenders in that country that are still occurring. And subjectively, this means it's very difficult for citizens to know what is the narrative to tell oneself about unfolding events. Are you in the midst of historic change where things will be fundamentally different? Or is this just another iteration of previous attempts at an end to conflict that usher in a brief period of peace before a resumption of violence, or a brief period of change before repression continues as before? Finally, the fourth circumstance that I talk about is what I call fundamental uncertainty about authority. Where often you're dealing with periods in which competing standards for claiming authority coexist at once. And also you're dealing with the fact that given the state is implicated in wrongs that transitional justice processes take up and deal with, the question of why the state has standing to deal with them is an especially pressing issue, and one that can't be responded to using common moves in a lot of moral and political thought, because the state is not a neutral party to wrongdoing. The explanation for why the state has standing cannot be that it's an impartial arbitrator between victims and perpetrators, nor is the state in these cases often a representative of values to be vindicated by responses, but is rather a representative of values in need of repudiation, which is precisely what transitional justice processes aim to accomplish. So in these periods of substantial structural inequality, against a background of ongoing normalized wrongdoing, where there's suddenly uncertainty about where a community is heading, and questions about who has authority to deal with wrongs so as to facilitate a transition and meet the claims of victims and perpetrators, what does justice mean? I argue in my work that what justice means is not what a lot of accounts of retributive justice or corrective justice or distributive justice articulate and offer. And I'm happy in the question and answer period to sort of say more about why I think those aren't the guides we need in these moments. I'll just say briefly why I think, what I do think the question is, and then why answering that question is so fraught. I think the core question of transitional justice is what constitutes, or thinking about what constitutes the just pursuit of societal transformation. That the circumstances of structural inequality that's pervasive and normalized wrongdoing make transformation, where I think of that relationally, transforming the terms of interaction among citizens and between citizens and officials, absolutely necessary. And the third circumstance of serious existential uncertainty creates an opening where that transformation becomes a possibility, practically optional. But also where the second circumstance, the normalized wrongdoing, generates an independent set of demands related to what victims need and what claims we can make on perpetrators who are implicated in the wrongs that a lot of these processes take up. So we can think about what transitional justice involves in ways that are analogous to how we think about the morality of warfare. So it's common to recognize and think that war can fail to be just in one of two ways. It can be unjust by being undertaken for the wrong reason. That's what the crime of aggression sort of lays out. It also can fail to be just by being undertaken in an illegitimate or unjust manner. That's what war crimes help us articulate and specify. So too, I think with transitional justice processes, we can have two sources of moral failure. Failure to contribute to the promotion of societal transformation by failing to engage in meaningful efforts at institutional reform or laying out conditions for non-recurrence, and also failing to do things in the right way by treating victims and perpetrators appropriately and legitimately as their status as victims and perpetrators demands. Now, a lot of the empirical scholarship that I mentioned earlier calls on us to curb our enthusiasm when it comes to the expectations of what specific truth commissions, reparation schemes, or criminal trials are in a position to achieve. That while the rhetoric of transformation sounds quite promising, the ability of these processes to actually achieve transformation is quite limited. And this leads to the sort of limitations that are inherent to any effort at pursuing transitional justice, give rise to a couple of pressing complaints, moral complaints that I think an account of transitional justice has to be in a position to redress. One kind of complaint is just what I call the complaint of shaking hands with the devil, a complaint of the necessity of engaging with those that are viewed as illegitimate or responsible for injustice in ways that might lead to a legitimation, of those organizations or individuals. And I can say more about this sort of worry in the Q&A, but I'll just say briefly, I think engagement's ineliminable. It's an ineliminable part of ending conflict and repression, even in cases where a victory is decisive, like in post-genocide Rwanda. That the moral costs of refusing to engage with those that are viewed as beyond the pale are such that some form of engagement is necessary. And the question for me is, how do you do that with integrity? And I think part of the second and third challenges are trying to speak to what integrity looks like in forms of engagement. So the second complaint that's raised is that these processes end up selling victims short. That whatever commitment to dealing with past wrongs that exists, as increasingly exists as part of a negotiated end to conflict or as a move away from various forms of repression, whatever reparation schemes or truth commissions are set up, end up falling short with respect to vindicating the rights of victims. And that's a failure of transitional justice on its own terms, because vindicating the rights of victims and doing justice to victims is part of what transitional justice is at its core about. I think this complaint and the third complaint that I'm going to talk about in a moment raise a question about what progress towards changing patterns of interaction or achieving recognition for victims ought to be seen as good enough from the perspective of justice. And answering that requires, in turn, thinking about the conditions that make a compromise in what you're going to be able to achieve justified, and what makes living with the injustice that inevitably remains in every transitional context acceptable or tolerable to some extent. So one kind of consideration that can help shape or influence what counts as good enough could be the reasons why choices are made in terms of which wrongs will be focused on or what degree of reparations will be offered. So principled reasons for compromise could help us distinguish good and bad deals when it comes to the claims of victims or the kind of transformative efforts that's undertaken. So Daniel Weinstock offers reasons in the context of liberal democratic politics that I think are also salient in transitional circumstances for what could be grounds for not pushing or demanding and accepting less than what you take full justice to mean in particular cases. So one kind of reason he offers is that it could be a way of overcoming epistemic limitations of taking only one side or your own view with respect to a conflict into conflict. It could reflect a commitment to democratic community, a willing to negotiate and work with those who hold different views about what justice means, as well as a commitment to principled consequentialism, recognition of the risk that's involved in refusing to compromise itself. And I think this last point is on vivid display in Colombia when you see the objections that have been raised by the current president to the form of accountability that special jurisdiction for peace has for certain wrongs that were committed during the course of the Colombian conflict, and the manner in which the pressing of objections and the demanding for moral accountability has in certain ways jeopardized the prospect for achieving any justice at all. So there can be reasons that are principled for settling for less than what you think full justice demands. But I think there also has to be a threshold, a baseline below which you can't go and be credibly able to claim to be doing justice to victims or credibly contributing towards societal transformation. I think there are this points to one of the distinct risks of moral failure that's characteristic of transitions, that processes that are in other contexts viewed as undoubtedly processes of justice, criminal trials, reparation schemes, come to be seen as processes of injustice, trials as mere victor's justice, or reparations as tools to buy victims' silence. And part of the worry that gives rise to these concerns is the background context of impunity and lack of justice for victims that characterizes the pre-transition period. And so we have to think about what is the threshold and who defines the thresholds for the moral minimum that's acceptable to be able to claim that justice has been done at all to victims, or some degree of transformation has been furthered. Last point in 1 minute, because I know that we want to have time for Q&A, and I was given 30 minutes. So in 60 seconds, here's the third challenge and some degree of how to respond to it. The third complaint that's raised about transitional justice practice is that what happens is you end up entrenching the status quo. That in bending the constraints to the constraints of what's feasible to achieve in these moments, processes committed to ending war and ushering in a new period just simply end up reinforcing or reiterating unjust patterns of interaction. I think responding to this worry requires tending to the concerns that I was just articulating earlier, to show that you're not continuing the status quo ante of injustice with respect to victims, for example, and that there are good moral reasons for the choice that are being made that show you're trying to move beyond the status quo. But I think it points to another consideration that's relevant and is increasingly getting attention in the scholarship and practice. And that's a concern with looking at who is making the decisions that are shaping how transitional justice is pursued in particular contexts. And in particular, heeding or looking at the role that's played by women, members of historically marginalized communities, subnational actors, as there's a big push for ground up processes of transitional justice, and who's participating at key moments. The negotiation to end a transition, the choice of transitional processes, whether you'll have truth commissions or trials, amnesty, or some combination of them. Who's participating in the functioning of these processes, who are the judges participating in the special jurisdiction for peace, who are the commissioners of truth commissions. And the thought behind paying attention to this set of considerations, the reasons that lie behind it that are articulated are threefold. One is epistemic, that our knowledge of the consequences of wrongdoing will increase and be more comprehensive to the extent we have greater participation. So the social and physical and psychological consequences of rape for men versus for women are very different. And so being able to have victims who are in a position to speak to those differences or be aware of those differences in the formulation of processes is important. So too our knowledge of the conditions that facilitate wrongdoing. And so what it is that needs to be combated for the status quo to change. But beyond the sort of epistemic, and this ties into one of the talks that will come in a moment, conditions of what facilitates and the consequences of wrongdoing. Another kind of argument looks at how, by paying attention to who's in charge of making decisions, we avoid duplicating injustice. We avoid repeating patterns of marginalization that are part of the characteristic way in which decisions are made during periods of conflict or repression. And finally, another thought that's articulated is we kind of model the relationships we hope to see moving forward in communities. And so these might be ways in which you could gesture at how what's happening, while it may not be wholesale transforming the status quo, is not merely replicating the status quo in ways that could make a moral difference in particular contexts. So I'll stop there. I see a number of questions in the queue that I'm glad Joe gets to curate and not me. And I'll just end also by saying that you're more than welcome, if you have interest in transitional justice, in reaching out to me by email with particular questions you have if they're not addressed here.
Okay, well, thank you so much, Colleen. We can't do more than applaud like this, but we can at least do that for those few of us who are on your screen. So can I just tell participants, if you have a question, please put it in the Q&A. There's a function in there that you might find very useful, which is the sort of upvote for a question. So if there's a question in there that you really want answered, then if you upvote that, it will come up to the top of the list, or towards the top of the list. In the meantime, I have a number of questions that were set before. I noticed, Colleen, as you were talking, my internet connection is not fantastic. So I might, if I disappear, then the questions are in the chat. David and Katie are moderating the questions, and we'll send them to you, so we go from the top. But I'll do that in the first instance. It shouldn't be a problem. So the first question we've got, which came up very, very early, almost half an hour ago, I think, from Abdu Nassar, who asks, how would we see the Indian case of getting independence from British occupation and then drafting its own constitution? So this will be a very popular question with the audience because we have a lot of participants from India here. So how do we think of India as a case of transitional justice?
Good. Okay, so here's, so I'll give 2 points of what's especially interesting about that question. So a lot of the movement of transitional justice scholarship is to focusing more clearly on post-colonial contexts, movements of colonial independence, and sort of lingering legacies of colonialism as shaping both periods of conflict and repression, and also continuing to shape processes of transitional justice and how we kind of decolonize transitional justice scholarship as well as practice. The other point to say with respect to the Indian case is that the emphasis on constitution making is especially apt. So one of the areas where you see fundamental transformation occurring is in the constitutional amendments or drafting of new constitutions that accompany a lot of transitional periods. Now, you don't see, as you did in the case of India, always, or in the case of South Africa post-apartheid, a drafting of an entirely new constitution. You can see, as in the case of Colombia, a modifying or amending of a constitution that's already existing and in place. But areas of interest, so I don't know all of the details of the Indian case to speak to them specifically, but here are some of the factors that are relevant when looking at the constitutional drafting and process from the perspective of transitional justice. One of the areas that matters is in terms of how citizenship is defined and drafted, especially against a background of historic lack of recognition or marginalization of populations. What are the terms and how are the terms for citizenship defined? That's one area that matters. And are they defined in a way that kind of duplicates or replicates marginalization or sets conditions where not all groups within a community are in a position to be equally recognized as citizens and with the identities they have or not? So one of the, looking at Northern Ireland and referencing Brexit really briefly in a way that presses on the Good Friday Agreement, one of the conditions of the Good Friday Agreement was recognition of the dual national claims of the nationalist and unionist communities there. So allowing for birthright recognition as Irish or British or both, but not forcing a British identity on anyone who didn't choose to identify in that way. And how Brexit is sort of reintroducing a pressure of necessarily identifying as British to the objection of many in the nationalist community who don't identify in that way. So one aspect of constitution drafting is in the defining of citizenship. The other aspect is in the extent to which constitutions deal with legacies of wrongdoing. So how is it that constitutions, whether they are only forward-looking or also are backward-looking in attempting to redress wrongs from the past? So I've argued in work that's coming out, one of the limitations of the Civil Rights Act, which wasn't a constitutional, an important legislative act in the context of the United States, that ended Jim Crow era segregation, it didn't deal with the legacies of wrongdoing from that era. So another place of constitution drafting that matters for transitional justice is thinking about whether and to what extent wrongs of the past are recognized and seen as sites and locations of redress. So again, I would please email me with or any other individual who has more specific questions about the Indian case in the context of Indian independence that you're wondering about what transitional justice would say, or whether this would be a case of success or failure. And I'd be more than happy to sort of engage with you about that in those greater details. But hopefully that gives some sense of what questions are relevant to be thinking about.
Okay, thanks, Colleen. So we've got a long list of questions, so I will continue to take them one by one, but Colleen, we maybe have 10 or more already up and not a lot of time, so
okay.
we can try to be
Yeah.
concise. So fascinating question, very relevant to the current situation from Sumaya Kumar. There has always been debate about whether the definition of transitional justice should be limited to post-conflict settings, or it should be expanded to consider cases of grave violation of human rights without a conflict. In this context, it has been proposed that the global acceptance of the systematic abuses associated with natural disasters, which intensify existing divisions in society, can be considered an area of interest for transitional justice. So I suppose the question is, do you agree that transitional justice doesn't always require situations of post-conflict or even regime change?
Yes, so I agree. So one of the so that points to an area of robust debate in transitional justice scholarship, which is, what is the limit of cases? What is the scope of cases that could plausibly be seen as falling within transitional justice? And that's part of the reason I came up with these, was driven to think about these circumstances of justice to give us resources for delimiting cases. So there's nothing necessary about conflict as such. Conflict can be a source or a product of existing inequality, and that's what matters from my perspective, as well as a cause of ongoing human rights abuses, which is what is the other thing that matters from my perspective. So you're exactly right that natural disasters, so short answer, no, conflict isn't necessary, though it's often a common feature. It's not a constitutive condition that needs to be present. And the case of natural disasters is especially interesting because it does exacerbate pre-existing inequalities. And so thinking about what would a transformative policy with respect to natural disasters look like is one that I think merits further attention. Katrina, in the case of the US, is a natural disaster that speaks to the ways in which it both reflected and exacerbated existing structural inequality in the US case.
Okay, thank you. So the next question pushes the scope maybe even further. So this is from Yoriki Kapimbua, and who asks, which conditions are sufficient to curb poverty and social exclusion of youth from active labour market participation? So this is thinking about school to work transition. So is that within the scope, or is that another topic for you?
So it could be implicated insofar as thinking about what are the conditions that are needed for there to be a genuine opportunity to avoid poverty, are relevant to the kind of discussion before. But I guess one thing also to say is there can be overlap. Transitional justice can have limits to its mandate, which other policies of social reform can sort of take up and complement. So when you think about transforming political relationships within a community, or dealing with, and this is picking up on the talk from yesterday, different forms of social exclusion, not all of the modes of social exclusion or worry about lack of labor market participation need to be framed as transitional justice efforts. What's distinctive about transitional justice efforts is when you link the redress of particular wrongs with the broader process or effort of trying to change broader patterns of interaction. But you can pursue obstacles to youth participation or youth unemployment in ways that aren't tied in that way to dealing with past wrongs, that would make those efforts not necessarily efforts of transitional justice as such.
Okay, thank you. So we now have Sebastian Rudas, who asks, could you share your thoughts about polarization about processes of transitional justice when it's seen as just only by half of society and the other half sees it as deeply unjust, as in Colombia? What are your thoughts about situations when half the population see a peace deal as compromising upon precisely what should not be compromised?
Yeah.
Tough question.
Right. So that's exactly right. So here's a couple of thoughts. I think transitional justice will always by its nature be polarizing. And that's because insofar as you are seriously committed to tackling structural inequality and dealing with legacies of injustice, that will be uncomfortable for those who benefit from the current institutional structure, who aren't harmed by the inequality that exists, and who may have been complicit or at least not directly suffered from human rights violations in the same manner, to the same degree as others within a community. So I think polarization, the first point is that it's inevitable. And one sign of undertaking serious efforts of transitional justice rather than cosmetic efforts is that they're controversial, because robust structural change will be controversial. For me, the key question is, how do you think about managing the polarization? How do you think about establishing the possibility of seeing processes that are deeply polarized as nonetheless legitimate? And I think that speaks to looking at the reasons for the compromises that are struck that I mentioned earlier, that they are a product in the Colombian case of long-standing negotiations between parties in conflict, by drawing attention to the ways in which there are, in many cases, just deeply incommensurable narratives of conflict and deeply incommensurable narratives of who is in fact the perpetrator, whether it's the Colombian government or the FARC, depending on the community that you're from, and who were victims, to create space for recognizing that one's own story of what happened in the conflict isn't comprehensive in capturing the whole truth about what happened in a particular place. So that's the other thing, thinking about how you deal with polarization in a way that won't make processes ineffective or being undermined or contested in a way that leads to them being disbanded, but rather creates conditions for getting the kind of epistemic humility, getting the kind of willingness to cooperate and compromise that's constitutive of democracy, where you can't always push your point, and getting recognition of the risks that are entailed in terms of resumptions of violence or resumptions of repression if you don't acknowledge the compromise that needs to be struck in particular cases.
Okay. Thanks so much. So the next question is from Beatrice Mayans, and it's about punishment.
Yeah.
So do you think that in those cases where parties to a conflict decide to investigate and try perpetrators of mass crimes, an expressive or communicative theory of punishment is more suitable for transitional justice contexts? What role, if any, may play of alternative sanctions such as community service and achieving not only a certain level of accountability, but also reconciliation and reparations, e.g. Colombia again?
Good, exactly right. Okay, so my view is that I don't think there's any necessary tool that must be adopted in order to meet the moral goals of transformation or of doing justice to victims or justice to perpetrators. So I don't think accountability for perpetrators requires, or that there's necessarily a sacrifice of justice if punishment or criminal trial and punishment doesn't occur. And I've got reasons for why I think there ought to be much more cultural variability in what satisfies or counts as an acceptable response to perpetrators. But part of those reasons speak to the other point that you were making about the expressive views of punishment as being apt. And I think that's exactly right. Because I think part of what our interest is in thinking about whether a choice ought to be with a truth commission or criminal trials or some other more localized process for accountability for perpetrators or recognition of victims, what matters is what these processes can plausibly, what meaning they can plausibly be seen to have in the community of interest. So if the goal is to recognize those who were victims and as rights bearers, as those who have been wronged, then thinking about what process in a given context will communicate that successfully matters. When thinking about the aims with respect to perpetrators, what will count as condemning conduct that should be viewed as unacceptable, and establishing conditions for judgments or attributions of responsibility to be given to perpetrators be in place. So I think the expressive route is the way to go. And I think part of what we need to do is be much more open to tools beyond the list that I mentioned in terms of processes that will be meaningful and effective in achieving the core goals of transforming relationships and meeting the demands on victims and claims of victims and demands on perpetrators. And I think also empirical scholarship is really helpful here as well, and knowledge of context, what can be construed as meaningful, and participation by members of particular communities who are best positioned to judge what will be meaningful in a given place.
Okay, thank you. So we now have a question which I understand has a very large number of votes. So this is a highly supported question from Lawrence Huang, who asks, how does transitional justice deal with the problem of external actors? For example, the role of primarily American multinational corporations and state agencies collaborating with political elites to support and maintain authoritarianism in late 20th century Latin America. Is transitional justice, like many other approaches to justice in political philosophy, conceptualized on a national scale, and how would it address an increasingly globalized world? So you can see why that's such a popular question, I think.
No, that's an excellent question. So I think there's a number of different ways of tackling it. So I think that, so what is the appropriate scope or site of transitional justice? I don't think there's a universal answer to that question. It'll depend on looking at what the dynamics of conflict are in a given case. And in some conflicts, the transnational character of where violence took place might be absolutely essential for defining the relevant scope. Like you would miss important dimensions of conflict if you were limited to a national scope. In other cases, it might make sense to focus or limit transitional justice processes to national borders, but where that need not entail not looking at the role that external or third-party actors played. So there's one question of who is the subject of relationships in need of transformation that transitional justice processes will focus on. And as part of that, a separate question could be who are the actors and perpetrators that need to be held to account for particular wrongs that occurred during a given conflict. So in the case of Colombia, you could argue that it makes sense for there to be a national focus on transforming relationships among Colombians, but that processes of accountability, given the role of American actors and multinational corporations in the course of that conflict, and the ways in which there's transnational dimensions to the drug trade, which played such a critical role there, that the boundaries of accountability need not and should not be limited to national actors. So I think thinking about what would be effective mechanisms for third-party accountability, what does accountability for multinational corporations that can be both morally defensible and effective look like, are exactly where a lot of the direction of transitional justice scholarship needs to go. And thinking about what is, transnational transformative justice look like. Won't be the same as what justice looks like in a particular state context. And so theorizing what possibilities exist there is exactly right. But to start with what I said at the beginning, I don't think there's a single answer when it comes to scope. It depends on the dynamics of the conflict or repression of interest to get at what actors are relevant to think about in terms of accountability and what scope of processes and boundaries of relationships are those that need to be transformed.
Okay, so we're running rather short of time now. We do have time to take one more question, and I think I'll take a question from Diksha Pandey, who asks, how does the case of Afghanistan play out in this situation? While the Afghan government and Taliban have engaged in talks, the transitional process is marred by ongoing conflict, and how does this explain the point of negotiations with the illegitimate party?
Yeah, that's good. So the case of Afghanistan is interesting. It's one of and Syria comes up in raising a similar sort of question of whether transitional justice is appropriately something that's pursued kind of post, or whether it can be pursued in the midst of ongoing civil war, or in the midst of ongoing negotiations. Afghanistan's also interesting because of the ways in which it raises, shines attention, which wasn't implicit in your question, but I just want to flag, to dynamics of power. The ways in which the possibility of accountability for American actors in the context of Afghanistan led to the revoking of visas on the part of the prosecutor for the International Criminal Court by the American government, draws attention to the ways in which we got to think about and problematize power relationships as shaping transitional justice processes and how we deal with dynamics of power in these cases. I don't have a clear set of thoughts when it comes to negotiations in the midst of conflict and sort of the full aptness of the use of transitional justice language. One thought is what you want to try to do through negotiations in the midst of conflict is be attentive to creating conditions where the pursuit of transitional justice becomes possible. And so not engaging in negotiations or trying to structure conflict in a way that forecloses the possibility of negotiations. And I guess the last point is one of the tragedies of transitional justice is that a lot of the actors that you're dealing with are actors that you wish you didn't have to deal with because of the morally heinous character of the actions that were undertaken. And in my view, unfortunately, some form of engagement is inevitable. And so this question of what does that look like in ways that can happen with integrity, where you can't on the one hand have too many red lines or excise too many groups, or what you are trying to achieve just won't be effective because it'll exclude too many actors, but where you can have some red lines, and what do those look like? Again, it's not a very specific and articulate answer, but I think it's one of the hardest questions, kind of coming to recognize that part of transitional justice is dealing with morally heinous actors, unreasonable actors, those liberal political theorists like to exclude from the scope of deliberation, and thinking about how you can do it in a way that's morally defensible.
Okay.
So I'll stop there.
Yeah. Okay. And in doing that, in fact, you've answered or at least addressed Patrick Nogoy's question about shaking hands with the devil as part of this process, and how can you maintain integrity. But unfortunately, we don't have time to discuss that any further. So I think this has been a wonderful session, both in terms of Colleen's presentation and your excellent questions and engagement, but also just like to add a type of methodological reflection in a way, because what Colleen has done is it's, as she said early on, this is to reject ideal theory, to reject the idea that all philosophers should do is come up with theories of justice and try to convince each other that we've got the better one, and that rather what we need to do is to get to grips with the real world. And I think what she's shown you is how the world opens up to you if you do that, because it turns out there are so many problems in the world, so many ways of doing non-ideal theory or non-ideal political philosophy. And transitional justice, I'm not sure how well known that was as a topic before Colleen started, but in a way for analytic philosophers, she's invented that topic for us, so in her gratitude. But at the same time, I think that her incredible grasp of the empirical facts shows how hard this work is as well, that you actually have to know stuff if you're going to do this properly. And that, I think, does put some people off, and they would much rather just be thinking about the concepts rather than having to look at the world. And what we know is the world changes fast as well. So you look at it one year and you look at it the next year, and it's quite different. And transitional justice, I think, would be an area which moves faster probably than many others because of its nature.